Hello, I'm Professor Shazia Choudhry. I'm a Professor of Law at the Faculty of Law at the University of Oxford, and I'm also a Tutorial Fellow in Law at Wadham, and the Tutorial Fellowship is named after Geoffrey Hackney. I'm also the Qua Geok Choo Visiting Professor here at the Law School. So the lecture is going to be covering the international human rights law and obligations in relation to victims of domestic abuse, and particularly their experiences in the family justice system all over the world. And the reason why this is important is because we very often don't hear about what happens in the family court proceedings in relation to domestic abuse victims. And it's also particularly important because separation for domestic abuse victims is actually one of the most dangerous periods of their lives. And so it's actually more important, I think, for the court to actually think about the risk assessment that's needed in relation to post-separation contact between a perpetrator of domestic abuse and the woman and the children, which it often is the women and children. The majority of victims are women and children. And so what's often happening is that family courts operate in a kind of fairly under the radar way, because obviously for reasons of privacy in relation to children, not very much is known about how family courts actually deal with these issues. And what we're hearing from a lot of victims of domestic abuse is that family law proceedings are often used as another way of continuing the coercion and control that they experience in the perpetrator. And that's obviously very disturbing, but more importantly, the family courts can often provide, unfortunately, another way in which abusers can continue to harm mothers and children as victims of domestic abuse. As a result of that, we often have unfortunately seen and continue to see a number of mothers and children who have been victims of homicide because the perpetrator has been allowed access to them, unfortunately, through the family justice system. And so that's why it's incredibly important that the family justice system responds in a manner that keeps those victims safe, whilst also appreciating the need to maintain contact and family relationships where possible. I think the reason why human rights law hasn't had the impact that it has is one of the reasons why human rights law hasn't had an impact in lots of other areas, which is there's a huge implementation gap in relation to what national governments agree at the international level, so they can sign treaties, sign up to various obligations, and we've seen the courts, the international courts and also regional courts also establishing standards such as the due diligence standard. But what we're not seeing is those standards and those laws actually being implemented fully across the globe really. Lots of countries do have an implementation gap in general when it comes to human rights treaties, but in particular in relation to areas that concern, unfortunately, women and children. And it's something that feminists have been talking about for a long time, about what we call the public-private divide, in the sense that international human rights law was supposed to remedy the absence, really, of human rights coming into those kind of private areas. And family law is definitely one of those private areas that's been very difficult for human rights law to penetrate in an effective way. It's a huge project, and just in itself there isn't just one answer. I think it obviously requires lots more training in relation to all family justice professionals. So that's not just judges, it's also lawyers, and it's also particularly in relation to family courts, court-appointed experts who often aren't lawyers but who are tasked with probably the most important task, which is reporting to courts on what they think should happen in relation to the best interests of the children. So I really think that all professionals involved in the family justice system need to appreciate why human rights law and human rights standards are particularly important, and the need to protect women and children from further abuse in relation to perpetrators. In addition to that, I think we also need to see national government stepping up and ensuring that courts are actually implementing their domestic obligations, because very often, for example, in the UK, we have the Human Rights Act. There's an obligation on the courts to ensure that human rights are respected. But there's very little monitoring of that actually happening, and I think not as much encouragement as perhaps there could be. So I think we need monitoring from national governments, and we also need encouragement for courts to actually comply with their obligations under the national domestic human rights standards that are there. Of course, there are some countries that haven't got domestic human rights legislation, but that doesn't matter either, because often these states have signed treaties such as CEDAW and are still obliged to comply with the standards that are at least being set at the international level. So those are a number of ways, I think, in which we can try to improve the situation, but it's definitely about increasing awareness and education about the application of human rights standards in situations such as this amongst the legal profession primarily, which is one of the reasons that I'm doing the talk today.